Okay, let's unpack this. Today we're diving into the National Security Act of 1980, the NSA. It's one of India's toughest preventive detention laws, and it's been in the news again, hasn't it?
Yeah, absolutely. The recent detention of Sonam Wangchuk, the climate activist, really brought it back into focus. It shows just how broadly this law can potentially be applied.
Right. So our mission here is to get a handle on what the NSA actually is and how it works.
Exactly. And you need to grasp this key point. It's basically the state's power to detain someone before they supposedly commit an act. It lets the central government, state governments, or even specific officials like DMs or police commissioners detain individuals
On what grounds, though?
on the suspicion that they might act in a way that's prejudicial to India's defense, foreign relations, security, public order, or even essential supplies. It's quite wide.
That's the crucial bit, isn't it? It's preventative, not punitive. You haven't necessarily been charged with anything yet.
Precisely. It's about stopping something anticipated.
And this whole idea of preventive detention, it's not exactly new to India, is it?
No, not at all. It has a long history, stretching right back to colonial laws. Post-independence, we had the Preventive Detention Act, and then came MISA.
Ah, MISA, the Maintenance of Internal Security Act. That one has a pretty dark reputation, especially from the emergency period.
It really does. It became infamous, used to jail thousands, many of them political opponents, often indefinitely. It was hugely controversial.
So when MISA was finally repealed,
Right. After the emergency ended, the NSA came into force a couple years later in 1980, and the claim was this time it would be different. It was supposed to have stronger procedural safeguards built in, to prevent the kind of misuse seen with MISA.
okay, safeguards, like what specifically?
Well, on paper, they sound decent. The detainee has to be informed of the grounds for detention, usually within 5 days, though it can be stretched to 15. They have the right to make a representation against the detention to the government.
And isn't there some kind of review?
Yes, there's an advisory board. It has to be made up of high court judges, or people qualified to be high court judges. They must review the detention order and the representation and report back within 7 weeks from the date of detention. Detention usually can't go beyond 12 months unless the board approves it.
Okay, that sounds somewhat structured,
Yeah.
but you mentioned issues.
Yeah, here's where it gets, really interesting and frankly quite concerning for civil liberties. Despite these procedures, the detainee has absolutely no right to legal representation before that advisory board.
Wait, no lawyer. You're facing potentially a year of detention based on suspicion, reviewed by judges, but you can't have your lawyer argue your case.
That's correct. No lawyer allowed in that specific proceeding. Your representation is just written.
That seems fundamentally tilted, doesn't it?
It does. And there's more. The government can also decide to withhold facts from the detainee.
Withhold facts. How?
If they deem disclosing those facts to be against the public interest, which is, a very broad term.
So you might not even know the full case against you, and you can't have a lawyer argue for you at the key review stage.
Exactly. It leaves enormous discretion in the hands of the authorities. Unchecked discretion, really.
So what can someone like Sonam Wangchuk or anyone detained under NSA actually do? What's the recourse?
Well, they can make that representation to the government. They wait for the advisory board review. But the main legal challenge is typically through the courts filing a writ petition.
Like habeas corpus.
Precisely. Habeas corpus, basically asking the court to review the legality of the detention. You'd go to the High Court under Article 226 or the Supreme Court under Article 32 of the Constitution.
So you're asking the higher judiciary to step in because there's no actual trial happening in a regular court.
Right. And this whole structure, the broad grounds, the limited safeguards, the reliance on high courts, this is where all the controversy comes from.
Because critics argue it's being misused, stretched beyond genuine national security threats.
That's the core argument. The examples seem to bear that out, the sheer variety of cases.
Yeah, let's look at that. It's been used against political figures, like you mentioned, Amritpal Singh, the radical preacher, or even someone like Chandrashekhar Azad from the BIM army.
Correct. But then you see it applied much more broadly.
Like during the anti-CAA protests back in 2020, several protesters were booked under the NSA.
Yes. And in certain states like UP or MP, it's reportedly been used in cases related to things like cow slaughter or even the whole controversial love jihad narrative.
That seems a long way from prejudicial to the defense of India.
It certainly seems like a drift from the original intent, doesn't it? It starts looking less like a tool against major security threats and more like, well, a tool to manage dissent or enforce certain social norms.
And the courts have sometimes pushed back, haven't they?
They have, occasionally. There was that Supreme Court case in 2012 you mentioned in the outline.
Right, the kerosene black marketing case. The court said the grounds weren't justified for using the NSA.
Exactly. And perhaps the most high-profile recent example was Dr. Kafeel Khan.
Oh yes, the pediatrician. Detained under NSA for an alleged inflammatory speech after the CAA protests.
Right. But then the Allahabad High Court quashed his detention, seriously questioning the grounds in the process, and ordered his immediate release.
So these cases highlight the tension.
Absolutely. You have governments arguing, look, we need this tool for national security, for maintaining public order. It's essential. But then you have civil liberties groups, lawyers, activists pointing to these examples and saying this is a blunt instrument, it's prone to misuse, it bypasses normal legal procedures, and it's being used for things it was never intended for.
So it boils down to this power the state has to detain someone without charge, without trial, until these limited remedies play out.
Yeah.
And it really makes you think, doesn't it? In any democracy, how do you define prevention?
Yeah.
Where's that line between necessary preemptive action for security and the fundamental right to liberty, to face your accuser, to have a proper legal defense?
That is the question. How much power do you give the state to act on suspicion alone? It's a tough balance.
Definitely something for all of us to consider.